Welcome back to the deep dive. Today, we aren't just looking at a law. We're looking at, well, a kind of trap. We are digging into Model Penal Code, Section 2.06.
Right. The technical title is Liability for Conduct of Another, but everyone really knows it as complicity.
And it's one of those sections that probably keeps defense attorneys up at night.
It absolutely does. It sounds so simple on its face, helping someone commit a crime, but the edges are incredibly sharp.
That's exactly what jumped out at me in the source material. It forces this terrifying question on you, the listener. How can you be found guilty of a crime, murder, robbery, you name it, that you never physically touched?
Right.
You didn't pull the trigger, you didn't crack the safe, you might not have even been in the same state, but the law says you are just as responsible as the person who did.
That is the very core of complicity. It expands the blast radius of criminal liability. It stops asking who did it and starts asking, well, who is responsible for it?
Yeah. So our mission today is to map that exact blast radius. We're going to deconstruct MPC 2.06 to understand exactly where that line is, the line between being a bystander and, well, being a criminal.
And to keep us from getting lost in the weeds, we should probably use a specific roadmap.
Okay.
First, we'll look at the innocent agent doctrine, how you can be guilty by basically using someone else as a puppet. Second, we will dissect the definition of an accomplice, focusing really heavily on the mental state and the specific actions required.
Then what?
Third, we have to look at the special rules for result crimes, which, they trip up a lot of people. Fourth, we'll examine defenses, specifically how you can terminate your complicity before it's too late.
And finally,
we'll look at the procedural independence of the accomplice. It's a really interesting part of the code.
Okay, let's unpack this. We'll start at the foundation, Section 2.06, subsections 1 and 2. This sets the stage. So what's the fundamental rule here? How does the code even begin to assign liability for another's actions?
The general rule is it's basically binary. Subsection 1 says a person is guilty of an offense if it is committed by his own conduct or on the conduct of another person for whom he is legally accountable, or both.
So legally speaking, there's no discount for outsourcing?
None. If you are accountable for them, their act is your act. And subsection 2 gives us the three ways that accountability happens.
Okay, what are they?
1, you cause an innocent or irresponsible person to act. 2, the code itself explicitly says you're liable, which is pretty rare. Or 3, you are an accomplice.
I want to double click on that first one, the innocent agent. This is MPC 2.062A. It sounds like something out of a spy movie, the villain who keeps his hands clean. But legally, what are we looking at here? Break down the elements for me.
It creates liability based on manipulation. To find someone liable under this subsection, we have a two-part test. First, the mens rea, the mental state.
The intent.
The actor must act with the culpability sufficient for the commission of the offense.
Meaning, if I want a murder committed, I have to have the actual intent required for murder.
Correct. And then we have the second element, the actus reus, or, the causation part. The actor must cause an innocent or irresponsible person to engage in the conduct.
I want to clarify irresponsible person. The explanatory note in the source material really highlights this. We aren't just talking about a friend who's, careless or bad with money, right?
No, not careless. In this context, irresponsible refers to legal capacity. This covers situations where you cause someone who lacks the capacity to be guilty, maybe due to insanity, infancy, duress, to commit the act.
So they can't be guilty themselves.
Exactly. Because that person is innocent or irresponsible in the eyes of the law, they can't be convicted. So the law treats the manipulator as if they committed the offense themselves. You are the principal actor, the other person is just the instrument.
Like a weapon.
Just like a weapon.
Fascinating. So if I trick someone to taking a laptop they think is theirs, or I swap a suitcase at the airport so an unsuspecting traveler carries drugs through security.
Exactly. You use them as an innocent agent. The traveler has the act of carrying the drugs, but no intent. You have the intent and you cause the act. The law just merges them, and you are the principal.
All right, let's move to the core of the module. This is the meat of the statute. MPC Section 2.06, Verse 3. This defines what it means to be an accomplice. Now, since we don't have a specific court case today, we're going to treat the statute itself as our fact pattern.
We can apply the analysis right to the text.
Exactly. So first, what is the rule regarding the required mental state, the mens rea?
Okay, so the rule is found in subsection 3A. To be an accomplice, the actor must possess the purpose of promoting or facilitating the commission of the offense.
Purpose. That is a high bar. It's not enough to just know it's happening.
That's right.
I have to want it to happen.
That is the critical distinction. Mere knowledge usually isn't enough under the MPC. Your goal, your conscious object, must be to promote or facilitate the crime.
So give me the classic example.
The hardware store debate. If I sell you a crowbar, and I know you're going to use it for a burglary, am I an accomplice?
Under the MPC, if I'm just the clerk ringing up a sale, probably no.
Correct. You have knowledge, but you don't have purpose. You don't really care if the burglary succeeds. You just want to sell the crowbar.
But what if you change the facts?
Well, if I sell it to you at a 500% markup because I want a cut of the loot, now I have a stake in the outcome. Now I have purpose.
Okay, now for the elemental analysis of the conduct, the actus reus. The statute lists 3 distinct ways to satisfy this. Walk us through the first conduct element in 3A.
This is the solicitation prong. The rule is, it is sufficient if the actor solicits such other person to commit the offense.
Let's apply that. What does that actually look like?
The application is pretty straightforward. If you ask or urge or command or encourage someone to commit a crime, and you do it with that purposeful intent we just discussed, you've satisfied the conduct element.
So I don't even have to help physically.
Nope. The solicitation itself is the act of complicity.
Clear enough. What about the second conduct element in 3A? This one seems a bit broader.
It is. This is the aiding prong. The rule states, it is sufficient if the actor aids, agrees to aid, or attempts to aid the other person in planning or committing the offense.
Attempts to aid. That phrase jumps out at me as a potential trap. Let's analyze that element. Does that mean I can be an accomplice even if my help is totally useless?
Yes, and that is a major aha moment for this section. If we analyze the text, attempts to aid is explicitly included. This means actual success in helping isn't strictly required.
Can you give us an example of how that works?
Sure. Imagine you're planning a bank heist. You ask me to disable the alarm system. I agree because, I want you to succeed. I go to the bank, I cut what I think are the right wires, and I tell you, you're all set.
Okay.
You go in and rob the place. Later, it turns out the alarm was already broken, or maybe I cut the wrong wire. It didn't matter at all. My help was objectively useless.
But I'm still liable.
You are fully liable as an accomplice. You attempted to aid with the purpose of facilitating the crime. The law is punishing your dangerous allegiance to the crime, not just how effective your help was. You don't have to be the but-for cause of the crime's success.
That is a crucial distinction. You can be an ineffective accomplice, but you are still an accomplice. Wow. Now, the third conduct element in 3A about omissions.
Right. This creates the duty to prevent. The rule is, liability attaches if the actor has a legal duty to prevent the commission of the offense and then fails to make a proper effort to do so.
So just standing by and watching a crime happen doesn't make me an accomplice, right? I see it all the time on the news.
Generally, no. The analysis really hinges on the existence of a legal duty. A random bystander has no duty, but a security guard, a parent, a police officer, they might.
And if that duty exists?
If that duty exists and you fail to make a proper effort to intervene because you want the crime to succeed, remember you have to have the mens rea, then you are an accomplice by omission.
So to recap the diagnostic so far, it's purpose to facilitate, PLUS soliciting, aiding or trying to aid or failing a legal duty. That's the formula.
That is the formula for the conduct of the crime itself. But here's where it gets really, really interesting. What happens when the crime doesn't go exactly as planned?
This leads us perfectly into our visceral hypotheticals. We have to talk about result crimes, which comes from MPC 2.064. So here's the scenario. I agree to help you assault someone. I hold them down so you can punch them. My purpose is to facilitate the assault.
Okay.
But you hit them too hard, or maybe they have a pre-existing condition we don't know about and they die. Now we are looking at homicide. I wanted the assault. I didn't necessarily want the death. How does the code handle that?
This is where we apply MPC 2.064. The text says, when causing a particular result is an element of an offense, an accomplice in the conduct causing such result is an accomplice in the commission of that offense if he acts with the kind of culpability with respect to that result that is sufficient for the commission of the offense.
Okay, that is a mouthful of legalese. Let's translate that for everyone.
It separates the conduct from the result. You were an accomplice in the conduct, the assault, that's established, but for the result, the death, we have to look at your mental state regarding that specific result.
So I don't need to have the purpose to kill them, even though purpose is the general rule we just talked about for complicity.
Exactly. That is the key distinction. Most manslaughter statutes, for example, require recklessness as the mens rea. So the question becomes, When you held the victim down so they could be beaten, were you reckless regarding the risk of death?
Holding someone down for a beating. Yeah, that seems pretty reckless regarding their safety.
Precisely. So even though you didn't have the purpose to kill, you had the recklessness required for the homicide statute. Therefore, you are an accomplice to the homicide. You own the result if your mental state fits the result.
Crime. That just significantly expands the risk for anyone helping out in a crime. You essentially own the risks of the whole enterprise you join.
You do.
Let's try another one. Hypothetical B. The incapable actor from MPC 2.065.
Right.
Let's say there is a crime that only a public official can commit, like accepting a bribe or official misconduct. I'm not a public official, I'm just a regular citizen, but I encourage a public official to take a bribe. Can I be guilty of a crime I am legally incapable of committing myself?
Here we apply MPC 2.0605, and the analysis is yes. The rule states that a person legally incapable of committing the offense themselves may be guilty if the offense is committed by a person for whom they are accountable.
So my lack of status doesn't shield me at all.
It does not. Unless the law specifically says otherwise, you can absolutely be an accomplice to a crime you couldn't commit on your own. You're helping the person who does have the capacity, so the law attaches their liability to you.
All right, we've covered how to get into trouble. Now let's talk about how to get out of it. We need to look at defenses and exceptions under MPC 2.066. When is a person not an accomplice, even if they fit the definition?
The statute lists 3 specific exceptions. First, if the actor is a victim of that offense, if you pay a ransom to a kidnapper, you are technically aiding them, but you are the victim, so no liability.
That makes sense.
Second, if the offense is so defined that the actor's conduct is inevitably incident to its commission.
Inevitably incident. That sounds like what? Purchasing drugs? You can't have a sale without a buyer.
Correct. But we usually don't charge the buyer as an accomplice to the sale. The legislature sets specific, usually lower penalties just for possession. We don't merge them via complicity.
And the third exception.
This is the big one. Termination of complicity. The defense of backing out.
Let's deep dive into termination then, subsection 6C. This requires a specific mini-analysis. It's not enough to just get cold feet and walk away, is it?
No, not at all.
So what are the elements to successfully terminate complicity?
The rule for termination is very strict. First, there's timing. The actor must terminate participation prior to the commission of the offense. You can't repent after the bank has already been robbed.
Okay, so timing is element 1. Then what do I actually have to do? Can I just ghost the group chat?
Absolutely not. Silence is not termination. You have to satisfy one of 2 conditions. Condition A, wholly deprive your conduct of effectiveness in the commission of the offense.
So if I brought the gun to the crime, I have to take the gun back.
Right. You have to completely undo your contribution. If you gave them the keys, you have to get the keys back. But sometimes you can't. If you gave them the plan and they've all memorized it, you can't really take that back.
So if I can't undo it, am I just stuck?
No. You move to condition B. Give timely warning to law enforcement, or R, make proper effort to prevent the commission.
Proper effort. That's interesting. It doesn't say I have to succeed in stopping it.
No, but the effort must be proper, which likely means reasonable and sincere under the circumstances. Calling the police is the gold standard here.
Right.
But just saying, hey guys, I'm out, and then walking away while they still have your map in your car, that is not termination. You are still on the hook.
That is a terrifying reality for anyone trying to exit a conspiracy. You really have to bring the whole bridge.
Absolutely. The law demands you actively neutralize the harm you helped set in motion.
We have one final area to cover. The procedural rules. This is MPC 2.067, the status of the principal rule. Here is the question. I am the accomplice. I drove the car. The police catch me. But the guy who actually robbed the bank, the principal, he gets off. Maybe he's acquitted. Maybe he gets immunity for testifying against someone else. If he's innocent in the eyes of the court, do I get to go free?
The conclusion is a resounding no.
Why? That seems completely counterintuitive. If there's no principal who's guilty of the crime, how can I be an accomplice to it? An accessory to nothing.
It feels weird, I get it. But MPC 2.067 explicitly disconnects your fate from theirs. An accomplice may be convicted on proof of the commission of the offense and of his complicity, regardless of what happens to the principal. The principal could be acquitted, immune, or never even prosecuted.
So the prosecution just has to prove the crime happened and that I helped. They don't actually need a conviction of the other guy.
Correct. Modern law recognizes that an acquittal might happen for any number of reasons. Suppressed evidence, a sympathetic jury, procedural errors. None of that changes the fact that you helped commit a crime. Your liability is based on your conduct and your culpability.
This has been a really rigorous tour of Section 2.06. We've looked at the innocent agent, the definition of an accomplice, the tricky result crimes, the strict requirements for termination, and the procedural independence of the parties.
It's a comprehensive framework.
So to wrap this all up, I want to give our listeners, especially those prepping for exams or legal practice, a tool they can use. Can you synthesize this whole discussion into a diagnostic checklist? If I am looking at a fact pattern, what are the steps?
Okay, here is your 6-step diagnostic for MPC complicity.
Step 1.
1. Check for own conduct. First, did the actor do it themselves? That's 2.06.
Work?
If yes, simple liability.
Easy enough.
2. Check for innocent agent. Did they manipulate an irresponsible person or someone lacking capacity? That's 2.06. 2. If yes, they are liable as a principal.
Step 3.
3. Analyze accomplice elements. If they help someone capable, you look at 2.063. First, mens rea. Did they have the purpose to promote or facilitate? Then actus reus. Did they solicit? Did they aid, agree, or attempt to aid? Or did they fail a legal duty?
Okay.
4. Check result crimes. If a result, like a death, occurred separated from the conduct, did they have the requisite culpability, like recklessness, for that specific result? That's 2.064.
5.
5 offenses. Are they a victim? Is their conduct inevitably incident? And crucial for defense attorneys, did they validly terminate by depriving effectiveness or warning the police? That's 2.06.
And the last step.
And 6. Ignore principal's fate. Finally, just remind yourself that the principal's acquittal is completely irrelevant to the accomplice's liability under 2.06.
That is a powerful framework. It really turns a messy fact pattern into a solvable equation.
That's the goal.
And here's a final provocative thought to leave you with. The model penal code focuses so heavily on the purpose of the accomplice. By saying that attempting to aid is enough to make you an accomplice, even if your help was totally useless, the code effectively shifts the basis of guilt. It moves from the harm caused to the intent of the actor.
That's true. It aligns accomplice liability much closer to the logic of, say, attempt liability.
It essentially says, the state isn't just punishing you for what you achieved, it's punishing you for your disposition. You are guilty because of what was in your heart and what you were willing to do, regardless of whether you actually made a difference. It polices the soul as much as the hands. Something to mull over.
A lot to think about.
That's the deep dive on complicity. We will see you next time.